Here are 3 employment laws that every business owner should know. My name is Bertha Barezzo, the managing shareholder of Barezzo & Barezzo, and today I'm going to talk to you about 3 most important employment laws that every business owner should know. Number 1, Title VII. Title VII is an anti-discrimination law, and essentially what Title VII does is it tells employers that you cannot discriminate on certain characteristics. For example, race, religion, gender, and so on and so forth. So the law really is aimed in protecting employees from discrimination based on a characteristic that they cannot change. And so employers, if you have, for Title VII, at least 15 or more employees, you need to pay attention because this law applies to you. However, if you're an employer with less than 15 employees, that doesn't mean you're out of the woods yet, because there are some laws within the county, the city, or the state that may mimic Title VII. In other words, give the same protections of Title VII, but has a very small threshold in terms of the number of employees that you have to have in order for your company to be subjected to the obligations of a Title VII anti-discrimination law. Number 2, the second law, the FLSA, the Fair Labor Standards Act. This law is aimed at ensuring that there are minimum standards for payment of the employees and also maximum standards for working. As an example, it really sets out what employees should receive, not just for their working wage, but also for overtime. Number 3, employment contractual laws. So with this one, there's not a particular law that has a title, but it's more so laws that govern the contractual relationship between employees and employers. So there are times that there's misconception by employers that they can just put together a contract and put any terms in it, give it to an employee, and it's enforceable. That's not the case. There are laws that tell employers what can and can't go into an employment contract, but more importantly, it sets the guidelines in terms of what would be enforceable. Just because it's in a contract doesn't mean it's enforceable. It could be against public policy. It could be something that you put in the contract that the courts just will not enforce. So it's important to be mindful of what laws are there to set the standard for what should be an employment contract. So an example of a case that we handled related to Title VII has to do with, interestingly enough, a law firm and a lawyer. So this law firm had been experiencing turnover for quite some time, and they recently onboarded, I say recently, but a year into her practice, they had onboarded a new lawyer. And within that year, this new lawyer gets pregnant. And so the lawyer did not inform anyone at management until she was about 6 or 7 months and she started to show. And unfortunately, this lawyer was let go. They did not call us first, but they let her go. And of course, the lawyer filed a claim for discrimination based on her pregnancy. And so we worked with the firm to, number 1, determine where did things go wrong. A lot of times when a termination is happening, it happens under very tight time constraints and things happen very quickly. So it was important for us to go back and take a look at the things that led up to this lawyer's termination, because from an outsider's view, it looked very black and white. She was pregnant, she told the firm what was going on, and the firm terminated her. But as we dug into the details and really took a look at what was going on, we realized that it wasn't the pregnancy that actually sparked the termination. There were some performance issues leading up to that termination. However, that didn't mean that this attorney couldn't come back and sue the firm for pregnancy discrimination. And that's the thing that I think a lot of employers discount, is that even if you're letting someone go for legitimate reasons, you have to be very careful of what can be perceived as being let go for a protected characteristic. So in this situation, the timing really didn't work in the law firm's favor, but we were able to really take apart what happened and provide some defenses to them. But my advice to them was, next time, walk just a little bit slower, call me first so we can walk through the termination together. An example of a situation related to wage and hour laws, specifically the FLSA, is one that unfortunately is all too common in my practice, because a majority of the lawsuits that are filed today are related to wage and hour issues. And so I try to emphasize to my clients to make sure that they're paying people correctly. In this particular instance, which didn't end well, but it didn't end as bad as it could have, we had a client who had contracts with government agency, and they had a lot of employees that they onboarded, but what they didn't realize was that when they were working with the government's contracts had a lot of nuances as it relates to how you pay your contractors or your employees. And so this particular client was quite surprised to get a call from the Department of Labor requesting an audit, because they had gotten a call from an employee, and the employee told the Department of Labor investigator that she was not getting paid correctly. And so sure enough, when the investigator went to our client and said, we were aware that an employee had called and said that she wasn't getting paid. And so the investigator wanted to see the payroll records, and we gladly shared them. And my client was happy to share them, because according to her, she was not only paying minimum wage, but she was paying above what the expectations were to pay via the government contract. But what my client missed was, even within that government contract, there were a lot of nuances related to PTO time, what hours they can work, how many hours they can work during the week via overtime. So there were a lot of little details that my client was not aware of. And so at the end, we ended up having to pay not only this particular worker who had complained, but we had to look at all of the employees that worked and make them whole per the contract that they had with the government. And so I say it could have ended worse, because if it would have come to our attention through, let's say, another lawyer, then sometimes what an employer has to pay back can be significantly more, because now you're having to pay attorney's fees. Sometimes the damages are liquidated, meaning there's a penalty above and beyond not just what you owe, but a penalty for just not paying them. So the number could have been possibly 3 times higher than what it really was. And so when I shared that with my client, they were thankful that it wasn't a pleasant process, but it could have been a lot worse. This is one of my favorite examples as it relates to employment contracts. And so we have a client who wanted to go to law school but never did, and so he felt very emboldened to put together a lot of the agreements that he rolled out for his staff. And when we went in and did an audit, we saw, a lot of the work that he proudly did, but the one glaring error that we noticed was he put a non-compete clause in all of his contracts for all of his employees. And so there's a few things that are a big no-no with what he did, but primarily the non-compete one, especially here in Florida, really has to be done judiciously. The courts are really cracking down and even eliminating any non-compete provision in your contract. But this particular client had a non-compete for the entire state of Florida for the next 10 years. And I understood why he did it. He said he had a lot of issues with employees setting up shop very close to him and competing with him. But I told him that wasn't the solution either. And furthermore, if that contract was to be disputed in court, he would more than likely lose, because non-competes have to be reasonable. They can't just be a blanket with the expectation that every single employee, no matter what their role in the company, has to follow. So we did a lot of unraveling of his contracts and paid particular attention to the terms that would likely not be enforced, and the non-compete was one of them. So if you're navigating any of the laws that I talked about in this video, or have any questions, and if you're an HR professional and you deal with these type of issues on a day-to-day basis and you need help, give us a call, click on the link below. Remember, we're employment lawyers. We're here to help partner with you through these issues, and we can also help navigate and avoid any legal risks that might come up for you. Thank you for watching the video, and see you next time.